Well, Wynn Williams is a 150-year-old law firm in Christchurch and Auckland, with a specialist focused in Auckland on corporate and finance law and raising capital. A shareholder agreement is a document amongst the shareholders of a company and the company itself that effectively manages the operation of the business and sets out the rights of shareholders with regards to each other and with regards to the company itself.
The types of things you typically see in a shareholders agreement are decision-making processes. They are set out in how decisions are made at board and shareholder level, anti-dilution provisions such as pre-emptive rights, also dispute resolution provisions, and sometimes protections for the company such as restraints of trade.
Yeah, a shareholder agreement is important for a couple of reasons. Primarily it helps set expectations of all of the shareholders in the company at the outset, and then on an ongoing basis it's a reminder of the company's duties to the shareholders and likewise the shareholders' obligations with regards to each other. Pre-emptive rights are effectively anti-dilution protection rights for shareholders. They can apply on the issue of shares and also the transfer of shares, the sale of shares. And effectively what they do is allow existing shareholders the right to participate in a new offer of shares. So they can buy a number of shares that effectively allows them to retain their percentage shareholding in the company. So drag and tag rights are one of the most common rights that you find in a shareholders agreement. And what they do is they do what they say. So in a drag situation, the majority shareholders, if they wanted to exit, if they wanted to sell to a third party, they could effectively drag along the minority into that sale so that a purchaser would be able to achieve an acquisition of 100% of the company. And a tag right on the flip side gives minorities some protection in the event that the majority is selling out. That minority can then tag into that offer and also realise an exit on the same terms. The key aspects of company law that are relevant to shareholders are often replicated in the shareholders agreement itself. So for example, the pre-emption rights that have been discussed. In addition to that, there are some fundamental rights at company law that cannot be changed. Examples of this are minority protection rights of prejudicial behaviour towards minority shareholders, information that needs to be provided by a company to all of its shareholders, and dividends and distributions, shareholders must be treated equally.
Securities law in New Zealand protects investors in a range of ways, but fundamentally it sets the process for raising capital and governs the information requirements that a company must provide to investors when they're investing in a company.
Equity crowdfunding is obviously something that's very new in the New Zealand market. It's dynamic. It is about investment, however, which involves risk. So the key point is, if you're looking at investing in a company, make sure you read through all of the information that the company is providing.